Good morning, this is your Kelso Report for Thursday, September 29th, and I'm your host, Clark Kelso. One of the things that all practicing lawyers learn early in their careers is that clients lie, just like everyone else. We educate ourselves to enter a profession and a judicial system committed to uncovering the truth. Yet our society is filled with people who will deliberately lie for gains large and small. People often behave as though there was a constitutional right to lie. The 2nd District confronted essentially that issue in Lefevre v. Lefevre, which involved the proper interpretation of California's anti-SLAPP statute. The plaintiff and defendant were married in 1995 and had 2 children. The wife began in 2003 reading books on the subject of divorce and money, including one book on the subject that included information about using false criminal accusations against a spouse in a divorce proceeding. Based on that book, she hatched a plan with a friend to bring false criminal accusations against her husband. In 2005, and further into that plan, she reported to a sheriff deputy that her husband had recently threatened to kill her and their children, and her friend confirmed the criminal report to the deputy. 1 week later, in reliance on her report and without any significant investigation, the Sheriff's Department filed a criminal case against the husband, charging him with making a criminal threat. That charge was tried to a jury, which found the husband not guilty. Not only did they find him not guilty, but the foreperson read the following statement into the record. Quote, "We, the jury, believe that the absence of any real investigation by law enforcement is shocking, and we agree that this appears to follow a rule of guilty until proven innocent. There was no credible evidence supporting the indictment. We believe prosecuting this as a crime was not only a waste of time, money, and energy for all involved, but is an affront to our justice system. This jury recommends restitution to the defendant for costs and fees of defending himself against these charges. This jury requests that our collective statement be made available in any future legal action relating to these parties." Close quote. Extraordinary statement. The judge granted the husband's motion for a finding of factual innocence pursuant to Penal Code Section 851.8 Subdivision E. Not surprisingly, the husband then filed an action against his now former wife and his former wife's friend, alleging causes of action for malicious prosecution, false arrest and imprisonment, negligent statements without justification, intentional infliction of emotional distress, and for damages for violation of his civil rights pursuant to Civil Code Section 52.1. The former wife and friend filed a special motion to strike the complaint under the anti-SLAPP statute, Civil Code Section 425.16. Their basic position was that their false report to the Sheriff's Department did not change the fact that the complaint was filed against them in response to their exercise of their First Amendment and statutory right to communicate with law enforcement. They argued that their report to the Sheriff's Office was a privileged communication under Civil Code Section 47, which made it also a protected activity under the anti-SLAPP statute. The 2nd District rejected the former wife's position. First, the court held that just because a communication may have been a privileged communication under Section 47, that did not automatically make it a protected activity under the anti-SLAPP statute. Second, the court noted that the definition of protected activity under the anti-SLAPP statute expressly referenced rights of speech and petition under the United States and California constitutions. And third, the court explained that there is no First Amendment right to make a false criminal report to the police. Therefore, the anti-SLAPP statute did not apply to protect the former wife's and her friend's false report to the police. In short, you don't have a constitutional right to lie. Well, now our one-liners. We begin with a couple of criminal procedure cases. First, in United States versus Barraza-Lopez, the Ninth Circuit held that the Federal Speedy Trial Act's 30-day pre-indictment time limit which runs from the date of the defendant's initial arrest, restarts when the underlying complaint is dismissed without prejudice and the charges are later refiled. Under this rule, when a charge is dismissed and proceedings are then reopened by the charge's refiling, the subsequent complaint, indictment, or information substitutes for the arrest or service of summons that ordinarily starts the 30-day clock. The statutory language in the Speedy Trial Act is actually ambiguous about whether the dismissal and refiling resets the clock. But the Ninth Circuit joined every other circuit which has addressed this issue by holding that the clock starts over in these circumstances. Next, in People v. Espiritu, the Second District held that the trial court had improperly required a criminal jury to reconsider its verdict, in violation of Section 1161 of the Penal Code, which provides that, quote, when there is a verdict of acquittal, the court cannot require the jury to reconsider it, close quote. In this case, the jury initially found not true the allegation that the defendant personally used a deadly weapon, but the court sent the jury back for further deliberations to reconsider its verdict, and they ultimately found the allegation to be true. Well, that order to reconsider the verdict turns out to have been in error. Next, in the area of constitutional law, in People v. Kisling, the Third District affirmed the commitment of the defendant to the Department of Mental Health as a sexually violent predator, subject to one exception. The defendant had challenged his commitment primarily by raising a series of constitutional challenges that have already been rejected by California's courts. The one claim that might have validity is a claim that the law violates equal protection, because sexually violent predators are treated by the statutory provisions less favorably than mentally disordered offenders and those who have been adjudged not guilty of a crime by reason of insanity. That claim was before the California Supreme Court in People v. McGee in 2010, and the court there remanded the issue to the lower courts to give the government an opportunity to justify the differential treatment of sexually violent predators. So, in yesterday's case, the Third District remanded and directed the Superior Court to suspend further proceedings pending finality of the proceedings in McGee. Next, an evidence case in People v. Robinson, where the defendant was charged with battery on a correctional officer. The Second District held that a conviction for being a felon in possession of a firearm was admissible for impeachment purposes, because it was a conviction involving moral turpitude, since possession of a firearm indicates a, quote, readiness to do evil, close quote. Having held the prior conviction was admissible, the trial court properly conducted the analysis under Section 352 of the Evidence Code and determined that the evidence was probative as to the defendant's credibility and not highly prejudicial. Next, an interesting civil procedure problem in United States v. Stonehill. Two taxpayers filed a motion to vacate a 1967 tax judgment against them based on evidence discovered through the Freedom of Information Act that the taxpayers argued showed the government committed fraud on the court during their 1967 suppression hearing. The district court held that the evidence showed misconduct by the government in the form of non-disclosure of some evidence, but did not establish fraud on the court, and therefore did not warrant vacating the judgment. To prove fraud on the court, the taxpayers needed to show more than mere non-disclosure or even perjury. Instead, the non-disclosure or perjury must have been so fundamental that it undermined the workings of the adversary process itself. Nothing so dramatic was shown by the taxpayers, and the Ninth Circuit affirmed in an extraordinarily long opinion, which the panel explained they thought was necessary to, quote, finally lay this litigation to rest, close quote. Next, a preemption case. In Dagelman v. Advanced Medical Optics, the Ninth Circuit held that state law tort claims under California's unfair competition law and false advertising law challenging the marketing of defendants' contact lens solution product were preempted by the Medical Devices Amendments of 1976. Under those amendments, states are not permitted to impose different requirements upon medical devices than are required under the Food, Drug, and Cosmetic Act. Because the Food and Drug Administration has promulgated specific requirements that apply to contact lens solutions, any attempt to impose different requirements under state law, including the unfair competition law, are preempted. Accordingly, the state law claims in the plaintiff's complaint were properly dismissed as preempted by federal law. Finally, a copyright case from the Ninth Circuit in Apple versus Citar Corporation. The defendant in a copyright infringement action brought by Apple raised a copyright misuse defense on the ground that the Apple operating system software license prohibits the use of the operating system on anything other than Apple computers. The defendant produced its own computers and was using Apple's operating system on their computers in violation of the license. The Ninth Circuit affirmed the trial court's rejection of the misuse defense, since there was no evidence that Apple's license restriction was intended to or had the effect of reducing competition in the market for producing operating licenses. Absent that evidence of harm to competition, there was no copyright misuse. The opinion is a very strong reaffirmation of the importance of licensing agreements in the software industry. And that's it for today's Kelso Report. Have a great day in the law.